Meenal Maheshwari Shah. I'm a business lawyer with more than 10 years of experience in various sectors and in advising businesses, being a business enabler along with being a gatekeeper. It's a difficult balance to maintain, but you learn it on the job. Today, we are here to talk about data protection and privacy laws. These are trending these days. The reason I think that I should talk about it is because I am a dual certified privacy professional, both in Indian and global laws, along with being an experienced business lawyer. So I hope this helps. Let's dive into what is privacy after all. You must be hearing a lot about the two concepts, data protection and privacy, and many times you may feel that they are being used interchangeably. But technically, these terms are different. However, they are very close to each other and hence they are used interchangeably. What is data protection? Data protection is basically the management of data, personal data of people that companies or organizations collect for their business purposes or for no purposes at all, as you must have recently seen the Airtel fiasco. Data protection is basically how you manage people's data, and how you ensure that it is managed in a manner that you're taking care of it. You're not giving it out to people that have nothing to do with it, or that could use it in a harmful way, or that could or who could sort of use that data and deploy it in some other industry, right? And however, what is privacy? Privacy is a slightly different concept. It is now a fundamental right in India, arising from the Constitution after the Puttaswamy judgment. Now, right to privacy is basically a right where it says that at the core of a human being, he has a right to share whatever he wants to share with someone and has a right to keep private whatever he wants to keep private. So now, how do these two concepts intertwine? Well, see, privacy, what happens is that privacy is something that I tell an organization when I'm sharing my data. Look, I'm sharing this data with you. However, these are the data points that I want you to keep private. Please don't share it with anyone. And these are the data points that, okay, I agree you can share it with some people. So I give them the instruction. That is privacy law, right? And then they manage, but through data protection, personal data protection laws, how to ensure that the privacy that I have demanded in return for sharing my data is adhered to. So that's how these two concepts come together, right? So now let's talk a little bit about what are the different forms of privacy. See, privacy, right now I'm stressing more about data privacy because we are talking about data protection, but actually privacy can be of many, many different types. Like it can be decisional privacy, like women want to have the privacy to make their own decisions these days. So that it's an example of decisional privacy. You can have physical privacy, right? You want to share your body with someone. You don't want to share your body with someone. You want to be in the house locked up. Sometimes you want to go out. That's physical privacy. There are proprietary privacy, right? Proprietary privacy is basically, this is mine, right? I bought it. This is mine. So now this is private to me. Please don't touch it because it belongs to me, right? Somewhat in the sense of a trespass, right? This property is mine. It's private to me. Please do not enter without my permission. So in this thread, there's another concept of informational privacy. And that's the privacy that we are going to be stressing on today, right? So now let's move on to what is the latest privacy trend in the globe. Well, privacy is a concept. While it is new to India, it is not new to many parts of the globe, right? People, if you are aware or if you read up about the West, etc., they are much more private from the very inception. That's how they're born, right? They're born private. And in third world, we are born social, right? So that's a cultural difference, right? However, any culture is reflected in laws of that country, right? And that's the reason why you will find that there are really detailed privacy laws in many parts of the globe, especially starting and very, very focused in Europe, right? Where they really believe it is a very, very important right. In India, on the contrary, we are still struggling with many other problems, right? Let's ensure that people don't get raped. Let's ensure that people are not they don't fall prey to corruption. They don't their physical security, etc. So because we are dealing with issues that are more fundamental in nature, there is much lesser focus on data privacy. However, now with the advent of internet and internet becoming a part of pretty much every citizen, whether for their personal life or professional life, internet, people have realized, has started playing a very, very important role. And when internet plays an important role, data automatically comes into the picture. And therefore, we have some sort of people who are talking about data privacy and the importance of it. You know that data privacy bill is underway, but it has still not become an act. So now let's think about it for a minute. Do we have any privacy laws in our country absent the data privacy bill becoming the law? The answer is yes. The answer lies, of course, the very first one that we've just spoken about is the Supreme Court's ruling that privacy is a fundamental right. However, how does it become fundamental right? Just by saying that this fundamental right, how do you implement it? How do you ensure that everyone's privacy is protected? Well, there is certain sections of the IT Act 2000 which in some manners can protect the privacy of individuals of our country or of persons who are dealing with Indians. For example, BPOs, right? Like BPOs in India, we pretty much have information of global citizens, but because an Indian is dealing in that information, he has a duty to ensure that in certain ways, the way IT Act governs it, which is not as wholesome as probably the privacy laws that exist. And that's the reason, of course, precisely that the data privacy bill is underway, but it does in certain ways protects the privacy of individuals, whether Indians or global, which are stored in computer systems in India. The very important section that you will find pretty much the whole privacy law encompassed in, it's section 43A. Now, what 43A does is that it says that an organization or a corporate that collects the data of individuals, which is personal in nature, which is sensitive personal information, not personal information. So the bar, it raises the bar. It only protects data which is sensitive personal information and not all kinds of personal information. And it says that please protect it. Do not allow any unauthorized access to that data to any person. If you so do, you will be in violation of the IT Act. Right now, this section 43A, actually, to tell you the truth, the IT Act was not promulgated with the intent to protect the privacy of citizens. That's the reason why this section 43A got added in 2008 when it sort of started becoming a hot topic, not in 2000 when the Act actually came into picture. In 2000, the provision that is the most closely associated with 43A is section 43, which said that any person who unauthorizedly accesses personal information, that person will be liable. So the liability was on the on the person who was going to access information, as opposed to what 43A does, that says that the X business, X company, you are the one who's gathering data for your business purposes of individuals. So it is now your responsibility to keep the data safe. And that's the shift that you saw in the IT Act. Of course, with the development of internet and all sort of, even tier 1, tier 2, tier 3 cities in India using internet and it becoming a very important part of their life. Section 43A only protects sensitive personal information. However, it failed to define what is sensitive personal information. And thereafter, what it did is that it said that the corporates have to protect this information, sensitive personal information, from wrongful gain or wrongful loss. While Section 43A created a sort of privacy regime in itself, what it did not do was, it sort of did not tell how are companies supposed to take care and have reasonable security to ensure that the data doesn't get accessed illegally. So therefore, in 2011, the government came out with Information Technology Reasonable Security Practices and Procedures and Sensitive Personal Data or Information Rules 2011. In that, they defined what is sensitive personal information. As you can imagine, sensitive personal information is information that the government considers really important. For example, your passwords, your financial information, your health data, your sexual orientation, etc. Anything that can be used against you because of the cultural biases or by criminals to sort of, mug you or loot you. So that's the reason why these rules became really important, because someone needed to define what is the information that the organizations want to protect, should protect, and secondly, someone needed to say how you're going to do it, right? Just organizations would think I have deployed firewalls and hence it is fine, but that is not really sufficient. You need to have a lot more measures which the rules tell you. The rules even tell you things like, please collect only that information that is necessary. Please don't go on collecting information that you don't even need. That would be the first way to protect the privacy of a citizen, because you're taking information that you don't need and then you will have to protect it unnecessarily. So start by data minimization, right? Ensure that you've taken consent from the person and to use the data thereafter. And if you intend to disclose it to another person, please take consent, because that's privacy, right? You are going to follow the rules that the individual sets for his information or her information, because it is theirs. So the ownership of the information was sort of tackled here, and the government said that the person who discloses the information or who shares the information is the rightful owner and should have the right to decide how that information can be used, shared, disclosed, collected, all in all processed, right? Because processing even sort of includes storage. Even if you're not using, it is just stored. Even that is included in processing your information. There's something called ISO 27001, right? These are the standards that are laid down. And the government said, if you use these standards, organization XYZ, then we will consider that you are using reasonable security practices, and hence we will give you the benefit of the doubt that you did your best to secure the data. So even if the breach has happened, it is something that we will excuse you for. So now let's move to section 72A. What 72A does is that it says that anyone who uses information about a person without his consent or contrary to the contract that you have entered into with that person is criminally liable, right? He's criminally liable for 3 years of jail term and a fine of around, I think, 5 lakh rupees, right? So this section makes it a criminal offense to use the data of a person. And here the beauty is that the words used are not sensitive personal information, but personal information. So this section is the one that could sort of come to your help if it was not sensitive, but personal information that was used by a company against your will, in breach of a consent that was taken, or in breach of the fact that a consent was never taken, right? So this is basically the substance of the existing regime in India of privacy law. And I hope you enjoyed this session. And I'll be back with Masterclass 2 soon and tell you a little bit about global privacy laws.